The probate process is the process of administering someone's estate. Whether you have a will or you don't have a will in place, the probate process is the process where you go into the Register of Wills and you have someone named as the executor or administrator of the estate and determine how that person's assets will be distributed. The probate process typically takes somewhere between 12 and 15 months to complete, and it's not necessarily a process where you're actively doing something for 12 or 15 months, but there is a creditor notice period in Pennsylvania, and it is 12 months. So from the time you advertise notice of the estate, that's when the time starts ticking until 12 months passes. You do have to consider that claims can still be made during that period of time. The costs associated with probate start with a probate fee that is based on the value of the assets in your estate, and it's kind of it goes up as you have more assets in Pennsylvania. There is a cost to advertise the estate. Depending upon where you are, that could be more or less expensive. Additionally, you're going to have to calculate in attorney's fees. And then potentially your executor will also take a fee if that's something permissible in your documents. The legal fees associated with probating an estate can vary significantly depending upon the amount of the assets included, the complexity of the estate, or if there are any issues with beneficiaries or creditors. Probate can be avoided in a couple of different ways. One strategy that some people use is a revocable living trust. If you fund all of your assets into the revocable living trust, meaning that you change the name of the assets from your individual name into the name of the revocable living trust and or name the revocable living trust as beneficiary on your different assets and accounts, then you would be able to avoid the probate process. Another way to avoid probate is by including beneficiary designations on any accounts where you can include beneficiary designations. And most often you can do that even on most bank accounts now. A third way is when you think about account titling. So if you hold your account jointly with somebody else, so if you're married and you hold an account jointly or you hold property jointly with someone else, then by operation of law, that property will pass to this other person when you die. If you have any questions about probate, please contact us at Hoelzle Law.